It all began innocuously enough, or so I thought. My house had always been my sanctuary, the one place where I could escape the chaos of work, traffic, and life's endless demands. Nestled in a quiet suburban neighborhood, it was surrounded by manicured lawns, neatly trimmed hedges, and houses that all bore the hallmark of an HOA's watchful eye. For years, I had lived harmoniously among the rules and regulations imposed by the Homeowners Association. I paid my fees on time, maintained my property diligently, and even volunteered for the occasional neighborhood cleanup. But despite all this, I was about to learn that in certain communities, even the smallest deviation from an HOA's rigid interpretation could spiral into a full-blown nightmare. It started with a letter, one of those official-looking envelopes that immediately makes your heart skip a beat. The return address bore the HOA president's name, a woman whose reputation for overzealous enforcement of rules preceded her. Among neighbors, she was known simply as Karen, though I would later come to understand that name barely scratched the surface of her notoriety. The letter was formal, laced with legal jargon, and its tone was pointed. I was allegedly in violation of a covenant that regulated the color of mailboxes. I paused for a moment, rereading the letter to ensure I wasn't misinterpreting the words. My mailbox, a modest, deep green fixture that had been there for over a decade, was supposedly a blatant violation of HOA regulations. My first reaction was disbelief. I mean, really, this was what had escalated to a potential eviction notice? Initially, I tried to dismiss it as an overreaction, thinking perhaps a simple phone call or email could resolve the misunderstanding. But my efforts were met with icy professionalism that bordered on hostility. Karen's responses were curt and final, refusing to acknowledge any previous compliance I had demonstrated. Instead, she leaned heavily on obscure clauses buried in a binder of HOA rules that I had never even read. It was as if she had been waiting for a minor technicality to assert authority, to flex power in a way that was completely unnecessary. I quickly realized that this wasn't merely a matter of mailboxes or minor cosmetic disagreements. It was about control. She wanted to make a point, and I was suddenly cast as the opponent in a battle I never sought to fight. As the days turned into weeks, the letters became more frequent, each one more aggressive than the last. The first few were merely reminders or warnings, written in that disturbingly formal language that seemed designed to intimidate. Then came threats of fines, escalating penalties, and eventually insinuations that I could be evicted from my own home. The audacity of such claims was staggering. I had never even missed a mortgage payment, never skipped an HOA fee, and yet here I was, being threatened with losing the roof over my head. Friends and family tried to reassure me that no HOA had the legal authority to evict a homeowner, but the anxiety gnawed at me relentlessly. Every night, I lay awake imagining confrontations, legal battles, and the humiliation of having my own neighborhood turn against me. Determined not to be bullied, I began an exhaustive investigation into my legal standing. I pulled every document I could find. The original deed to my house, all HOA correspondence from the past decade, bank statements proving timely payments, and photographs of my property taken over the years. I meticulously organized each piece of evidence, creating a binder that was nearly as thick as a small novel. The deeper I dug, the clearer it became that Karen's claims were built on shaky ground. The HOA rules she cited were often outdated or misapplied, and in some cases, they contradicted other bylaws. It was a bureaucratic labyrinth designed to intimidate homeowners into submission, and I was determined not to fall prey to it. The psychological toll of the situation was profound. What had begun as a minor annoyance soon became a source of constant stress. Every time I checked the mailbox, I half expected another threatening letter. Every interaction with the HOA felt like walking through a minefield, unsure which step would trigger another round of accusations. My neighbors, once friendly acquaintances, began whispering and casting curious glances, unsure whether to stay neutral or take sides. The social dynamics of the neighborhood had shifted subtly but unmistakably. Even casual strolls past manicured lawns were punctuated by the fear of encountering Karen or her allies, armed with their clipboards and righteous indignation. Despite the mounting pressure, I refused to be passive. I started attending HOA meetings, which quickly became exercises in absurdity. Karen would dominate the floor, reading aloud the same sections of the covenant as her repetition lent them additional authority. Whenever I raised a point, she dismissed it with a wave of her hand, as if logic and evidence were irrelevant in the face of her interpretation of community standards. Other members of the HOA board seemed hesitant to intervene, perhaps intimidated by her assertiveness, perhaps genuinely convinced of her correctness. It was an environment where common sense was subordinated to the letter of selectively enforced rules, and I was caught squarely in the crosshays. I also sought advice from legal experts, who confirmed what I suspected. An HOA could not evict a homeowner for such minor infractions, particularly when there was no history of noncompliance or malicious intent. But knowing this intellectually did little to alleviate the stress of living under the constant threat of legal action. Karen's letters had created a sense of urgency and dread that no amount of legal reassurance could immediately erase. I began documenting every interaction meticulously, emails, phone calls, in-person encounters, creating a paper trail that would eventually prove invaluable. Each entry was both a record and a shield, a reminder that I was not powerless. What surprised me most was the escalation itself. It wasn't enough for Karen to enforce the rules. She needed to assert dominance. She began citing minor landscaping choices, the placement of garden decorations, even the timing of outdoor lighting installations. Each complaint seemed increasingly petty, yet the tone remained menacingly official. It was as if the mailbox incident had opened the floodgates, and nothing I did would be sufficient to satisfy her sense of authority. The situation was exhausting, both mentally and emotionally. I found myself double-checking every decision, anxious that a new violation would be discovered before I could even correct it. My home, once a sanctuary, had become a stage for this absurd power struggle. Amid the chaos, I realized I needed a strategy. Compliance alone would not suffice, as Karen had shown a remarkable ability to invent violations where none existed. Instead, I focused on documentation, legal preparation, and calm persistence. I rehearsed conversations, anticipated potential arguments, and strengthened my knowledge of HOA law. The process was painstaking, but it was necessary to prepare for the inevitable confrontation. I refused to let intimidation dictate the terms of my life or my residence. Each day of preparation reinforced my resolve, even as the stress threatened to wear me down. Looking back, the conflict was as much about psychology as it was about property. Karen's insistence on asserting control revealed a fundamental misunderstanding of power. She believed fear and paperwork could compel obedience, but she underestimated the determination that arises when one's home is at stake. The battle had transformed from a simple disagreement over aesthetics into a war of principles, where fairness, legality, and common sense were the true weapons. I knew that the next steps, mediation, potential court appearances, and public accountability, would test me further, but I also understood that retreat was not an option. The sanctuary of my home, the stability of my life, and the validation of reason itself were on the line. By the time I finally realized the magnitude of the situation, the conflict had fully consumed my daily life. Every interaction with the HOA was tense, every minor detail scrutinized for hidden threats. Yet, amid the frustration and anxiety, there was a strange clarity. I understood precisely what was at stake, and I was ready. The mailbox, the letters, the petty complaints, they were all symbols of a larger struggle, a battle between unreasonable authority and a homeowner's right to safety, dignity, and autonomy. I had been forced to prepare, to strategize, and to stand firm in a way I had never imagined. And while the conflict was far from over, I had already begun to reclaim a sense of control, one meticulously documented letter at a time. The morning of the hearing arrived with a mix of tension, anticipation, and a strange sense of resolve. I woke up early, carefully reviewing my meticulously organized binder one last time, making sure every document, photograph, and record was in order. The weight of the previous week's stress felt heavier than ever, yet there was a newfound clarity in my purpose. This wasn't just about a mailbox anymore. It was about defending my home, my rights, and the principle that no person could wield authority without accountability. Dressed in professional attire, I left the house with a binder tucked under my arm like armor, ready to face what I had been preparing for. As I drove through the quiet suburban streets, I noticed other neighbors glancing curiously in my direction, some with sympathy, others with veiled apprehension. It felt like stepping onto a battlefield, though the only weapons we wielded were words, evidence, and legal reasoning. Arriving at the courthouse, I could immediately sense the tension that hung in the air. The hallway was bustling with the usual array of litigants, lawyers, and clerks, but there was a noticeable undercurrent of anticipation. My opponent, the HOA president, was already there, striding in as though the building itself were a stage for her performance. She was immaculately dressed, hair perfectly styled, and carrying a folder that seemed more intended to impress than to inform. There was a confidence in her posture, a smugness in her smile, that made it clear she believed she had already won. She greeted no one, acknowledged no one, but her eyes seemed to sparkle with the thrill of confrontation. In that moment, I realized that the battle ahead would require not only facts and evidence, but also the patience to endure theatrics. The courtroom itself was imposing yet orderly, a place where decorum was expected and distractions were minimized. As we waited for the judge to arrive, I took a moment to organize my thoughts, ensuring that my argument would flow logically and persuasively. I rehearsed silently, envisioning possible objections and responses. The hours of research, documentation, and preparation I had invested now felt like a tangible shield. When the judge finally entered, a quiet authority filled the room, instantly commanding attention. His demeanor was calm, patient, and professional, the very embodiment of impartiality. As he took his seat, he acknowledged both parties with a nod, signaling that a proceeding would begin. The HOA president presented her case first, launching into a rapid-fire recital of alleged infractions. She read aloud sections of bylaws, cited obscure clauses, and made sweeping generalizations about my supposed noncompliance. Her tone was confident, almost theatrical, as if the act of speaking loudly and authoritatively could substitute for evidence. She emphasized the mailbox incident, then branched into trivial issues regarding landscaping and decorative items, attempting to portray a pattern of disregard for HOA rules. There was an intensity in her delivery, a performative energy that made some in the courtroom shift uncomfortably. Yet beneath the volume and flourish, her argument lacked substance. The citations were misapplied, the rules selectively interpreted, and the claims often contradicted one another. Each time she made an assertion, I could sense the judge's slight raising of an eyebrow, a subtle signal that her performance was not having the intended effect. When it was my turn to speak, I felt a momentary surge of nerves, quickly replaced by focus. I stood, took a deep breath, and began laying out my case calmly and methodically. I presented my evidence one point at a time, showing clear documentation of timely payments, photographs proving compliance, and correspondence that contradicted the HOA president's claims. I emphasized the legal impossibility of an HOA evicting a homeowner without due cause and reinforced the principle that fairness and proper procedure must guide all enforcement. My tone was measured, deliberate, and unshakably professional. Each piece of evidence was presented with clarity, each argument logically connected to the next. I could feel the atmosphere in the courtroom shift subtly. The tension created by the president's theatrics was replaced by a quiet acknowledgement of reason and fact. The judge listened attentively throughout my presentation, occasionally interjecting with questions to clarify points or request additional context. His tone was patient but firm, a reminder that the court valued substance over spectacle. I could sense that he was assessing the credibility of both sides, weighing the evidence against the claims. When the HOA president attempted to interrupt or obfuscate, the judge's calm interventions reminded her, and the entire courtroom, that authority derived from theatrics held no power here. My arguments were rooted in reality, supported by documentation, and presented without exaggeration. It became increasingly clear that logic, preparation, and honesty were far more compelling than intimidation and pretense. The turning point came when I addressed the heart of the issue, the attempted eviction itself. I explained that not only were the claims against me unfounded, but the very notion of eviction for such minor infractions was legally baseless. I detailed the specific sections of HOA law and municipal regulations that protected homeowners from arbitrary action, emphasizing that compliance had been maintained throughout my residency. As I spoke, the room seemed to settle into a collective acknowledgement of the absurdity of the HOA president's claims. Even the judge allowed himself a subtle, knowing glance that suggested the matter was more ludicrous than threatening. The president's confident facade began to crack, her expressions flickering between frustration and disbelief as the reality of the situation became undeniable. When my final point was made, a profound silence filled the courtroom. The judge reviewed the documentation, cross-referenced the evidence, and then, with deliberate clarity, issued his decision. He dismissed the HOA's claims entirely, calling the eviction attempt baseless, frivolous, and without merit. The words seemed to resonate through the room, a validation not only of my case but of reason itself. The HOA president's face turned crimson, a carefully constructed image of authority shattered in an instant. I felt a mixture of relief, vindication, and a quiet triumph. The court had spoken, and justice, measured, rational, and impartial, had prevailed. Leaving the courtroom, I felt a weight lift from my shoulders. Neighbors who had watched the proceedings expressed quiet congratulations, some shaking their heads in disbelief at the audacity of the attempted eviction. I realized that the battle had not been merely about a mailbox or a minor infraction. It had been a test of resilience, preparation, and the courage to stand up for oneself in the face of unreasonable authority. My home was no longer a place of anxiety and stress. It was restored as a sanctuary, reinforced by the affirmation that reason, evidence, and persistence could overcome even the most absurd challenges. Reflecting on the ordeal, I understood that the experience had transformed me. I had navigated a labyrinth of bureaucracy, intimidation, and social pressure, emerging not just victorious but empowered. The HOA president, whose attempts at domination had been so meticulously planned, had been undone by the very principles she sought to ignore: fairness, legality, and common sense. The judge's reaction, calm yet decisive, underscored the fundamental truth that authority without justification is fragile, and that integrity and preparation ultimately prevail. In the days that followed, the neighborhood slowly returned to normal, though the memory of the conflict lingered. I had stories to tell, lessons to share, and a newfound appreciation for the strength of meticulous preparation and unwavering resolve. Each glance at my mailbox, a simple, deep green fixture, served as a reminder not only of the conflict endured but of the triumph achieved. The courtroom showdown had been more than a legal battle. It had been a reaffirmation that a home is not merely a physical structure, but a sanctuary protected by knowledge, diligence, and courage. And in that knowledge, I found not just relief, but a quiet, enduring pride.